Hello, and welcome to the Law School Toolbox podcast. Today we're going to be talking about all the different types of law school exams, so stay tuned. Your Law School Toolbox hosts are Allison Monahan, that's me, and Lee Burgess. We're here to demystify the law school and early legal career experience so you'll be the best law student and lawyer you can be. Together, we're the co-creators of the Law School Toolbox, Bar Exam Toolbox, the Catapult Conference, and the Trebuchet Legal Career site. I also run the Girls Guide to Law School. If you enjoy the show, please leave a review on iTunes. And if you have any questions, don't hesitate to reach out to us. You can always reach us via the contact form on lawschooltoolbox.com, and we'd love to hear from you. With that, let's get started.
As you may know, not all law school exams are created equal. Different types are common at different schools, but you'll probably experience a variety of exam types throughout your time in law school. Today we're going to talk about open book exams, closed book exams, multiple choice exams, and take-home exams. Understanding how to prepare for each one of these from early in the semester is one of the keys to law school success. So stay tuned.
Well, first up, Lee, do you have an opinion on what's the easiest type of exam and what's the hardest?
Well, in true lawyer fashion, my answer has to be, it depends. But
no.
I know, it's so shocking, isn't it?
Do we ever say anything else?
I know. But for me, and what I've seen for law students, I actually think that the closed book exam can be the most challenging because it usually involves, intense time pressure because it's in class, and it requires a lot of memorization, which takes a lot of time and advanced planning for studying. So although I typically prefer a closed book exam, I do think that for most students, they're probably seen as the harder ones. What do you think?
Well, it's interesting because I know you, from talking with you in the past, that most of your exams were the sort of traditional in-class closed book exams, whereas I don't think I ever had a closed book exam in law school.
Those cushy Ivy Leagues, man. They don't
I
make you
know,
work hard.
everyone just gets an open book. We're all special.
Exactly.
Like occasionally, very, very occasionally, I might have a multiple choice component that was closed book. But I don't think we ever had the sort of traditional, go in with you and your blue book and start scribbling type of exam, or obviously your laptop now. No, I think the bar exam was the first closed book law exam I ever took.
Do you think that made the bar exam more intimidating?
Well, I think, Ivy Leaguers are arrogant enough to think that we'll pass the bar. So, it definitely made it scarier.
Right.
Just because this was not something that I was used to doing at all.
Right.
So I think for me, like if you told me I had to take a closed book exam, that would probably be the hardest type. But that's mostly because, I just wasn't used to doing it. Also, like for me personally, memorization has never really been my strong suit. Mm-hmm. More of a big picture type of thinker.
Yeah. So,
my favorite exams were probably take-home exams because I felt like maybe I didn't know the material as well as everyone else necessarily, or like as someone else might know every detail better in their head. But I thought I could probably figure out the question and write something that seemed compelling.
Yeah. And you're a good writer. And so having that extra time too, I think can be good if you're confident about your writing skills.
Right. I was a better writer than I was a test taker. So, for me, it's like the more time I got in an exam, probably the better I was going to do. The less time, the more time pressured, the ones that were really these racehorse sort of lots of issues. You really had to know everything, even with an open book exam. And this is something we'll talk about later probably. But, if you have a 3-hour in-class exam with 3 questions, each question is 2 pages long, that's almost a closed book exam at that point. Because it's just, you don't have time to be thinking about anything or looking anything up. Versus like, a 24-hour take-home or even an 8-hour take-home. That's a different beast.
And I know that one of the arguments for open book exams is in practice, you don't actually have to memorize everything, and you typically shouldn't. You should cross-check things constantly.
Right. If you did in practice what you do on the bar exam, you would definitely be committing malpractice.
Exactly. So, that is definitely part of the reasoning for this movement towards open book exams, but I do think for students who are not Ivy Leaguers and are not necessarily in this class of students who are doing really well on all types of exams, that it is great practice to have a closed book exam. Nobody's really talking about whether or not maybe these falling bar passage rates might have something to do with the fact that the law schools are really moving away from memorization of these core 1L classes. And it's easier to go back and learn something again if you've already learned it once. So I think it's a mistake.
That's definitely true.
Not only that, it's a skill. You have to learn how to memorize massive amounts of information. It's not easy.
Oh, for sure. I mean, even, on the bar, depending on where you went to school, you might not have even seen certain topics before. I mean, in California, like I had never seen community property. I had to learn that from scratch. But even in Massachusetts, where I took the bar for the first time, there's stuff like commercial paper. And I'm like, what in the world is this?
Yeah, I have no idea what that would be.
I don't even remember. It's about like passing bad checks or something. I don't know. Like
interesting. I would be like, is that the stationery store? What? I don't know.
Yeah, I was like, commercial paper. Can you just walk down and buy that? But no, it's all about, like how businesses do something with money. I don't know. It's a wonder I passed the bar. But.
Did you have a commercial paper question on your test?
I mean, I think there might have been.
Oh,
I think
wow.
It was like always. It was one of those topics. It was like always on there.
Well, I will say I didn't take remedies, and I did have a remedies question on my bar exam, and I still did okay. So
yeah. Well, all right. Let's talk about the sort of classic in-class closed book exam. What are the real keys to success here? Like, how should people prepare for this?
Well, I'll take this one since these are my favorite. There are really a few things you have to think about with the classic closed book exam. One is you do have to memorize material, and you can't just memorize it in a big picture like, oh, I kind of know what I'm going to be talking about. You really have to memorize it to the extent that if I said, write down all of the rules for negligence, starting with duty, you could verbatim, time after time, write down all those rule statements.
Right. I mean, and you have sort of a story about realizing this, right? Like where your mother, who is a lawyer, kind of took you to task your first semester and said, look, you don't know this well enough, right?
Exactly. Happy Thanksgiving to me. I went home just about a week before my first exam, which was in torts. And my mom is sitting at the kitchen table. And she's asking me how my tort studying is going. And I say, oh, it's going well. Like, I understand torts. And then she says, well, give me the rule for, the duty for common carriers. And I was like, well, common carriers are different. And I start to kind of do this like hemming and hawing definition. And she basically has this, big moment where she says, that is completely unacceptable and you will not be able to take your exam that way. It was a very serious intervention. And I was kind of taken aback and saying like, I don't understand what you mean. She's like, you need to be able to tell me like exactly what the rule for the common carriers are and using any terms of art or, common language that is acceptable for these rules. Like you just can't make this stuff up on the fly. And she was completely right. I did have to scramble to learn the rules in that way for my torts exam. And then of course you get better at it as you go on in law school. But I think some of my classmates did not have, my mother shaking them a week or 10 days before the exam, telling them what they're doing was not going to work. So, you have to memorize and you have to memorize the language that's required. And then you have to have a quick recall. You have to practice writing out these rules as quickly as you can, because the next thing about these exams is you have very little time to get your work done. So you have to be able to write quickly, think quickly, organize your material quickly. And that's another big part of it. But you got to practice, because the only way to prepare for these exams is having done them over and over again. So that includes practicing, getting feedback, and rewriting. So you can really master what the professors are looking for. And if there are model answers, you have to study them and make sure that you can appreciate why your professors gave certain points for certain things. I think these are hard for some students because they hate the time crunch of the in-class exam. The memorization feels very overwhelming. And anxiety can really build up when you sit down to do one of these types of exams. But the best thing you can do is to not make your first time writing out one of these questions be when you sit in the exam room. It's really the practice.
Absolutely. And I think, if you do have model answers, that can actually be a great place to sort of understand how the rules really need to be written out. Because I think sometimes students get really obsessed with knowing every element of every exception of every rule. And that stuff is important and you do need to know it. But that's not sort of the be all and end all. It's not like you just get to go in and write down the rules and then you move on with your life. That's step one. And that's certainly critically important. And I think, having this sort of element by element understanding or a checklist approach or an attack plan for how you would approach a different, each topic, or what are the questions you need to ask? What are the order you need to ask them in? This is a lot more complicated than just being able to spout kind of like what is a common carrier.
Exactly. It's about the analysis. That's where the majority of the points come from. And that's using the facts from the fact patterns and making arguments and appreciating ambiguity and things like that.
Yeah, and one of the things I think sometimes can be helpful, obviously you can't go overboard with this, but if you are someone who gets stressed out on a test and you're concerned about forgetting and blanking on your memorization, it can be useful as soon as the test starts to actually write down, say, a cheat sheet, with your main attack plans or a checklist of the main things you're going to look for. And it could be a mnemonic device, just letters or whatever. And in a way, it's sort of a crutch, because if it's in your head to the extent that you could write it down, it's in your head. But you can still go ahead and, have that ready for you as that sort of security blanket. So if you do forget about something or you're not sure, you can look back at it.
Very true. And part of it is just the fact that you need to be comfortable writing this stuff down. I mean, when I would study for these closed book exams, I would actually, of course, this is before I had my fancy DVR, but I would watch TV at night after my studying was done. And when the commercial would come on, I would mute it and I would make myself write down as many rules for my upcoming exam as I could, as quickly as I could.
I think that's good. I think that sort of spaced repetition, that's a concept that's really popular in learning theories, is basically, you don't just look at something once.
Right.
And, you don't wait like weeks between looking at it. Your brain, in order to get from sort of short-term to long-term memory, you need to look at something on, say, once or twice a day. I mean, it's just like learning a language. If I go over some verbs or something every day, I tend to remember them. If I wait 3 weeks and look at like a fresh word, I'm like, wait, what was that again? I have no idea.
Yeah. And I think one of the things somebody told me when I was a 1L, which I didn't believe, which is really true, is they said, you're going to freak out about having to memorize all the rules, but you have to appreciate that everyone in the class is going to have the rules memorized. And you still have to focus on the analysis and writing the best essay using good issue spotting and quality analysis. And I actually didn't believe that most everybody would know the law going into the exam, but it's true. So it's like a threshold. Like, you have to know all of this material, but then you still have to be better than everybody else at the analysis to get to the top of the curve.
It's like you don't get to just go in and write down the rule.
No.
You have to do something with it. And I think that's really the piece where a lot of people kind of drop the ball, particularly the first semester, is they're so focused on like making sense of this material and memorizing whatever is in, an old outline or commercial outline or whatever. And then, they run out of time to actually try to apply it. So, if someone's listening to this and say it's October, ask yourself, like, have I actually tried to use this knowledge yet?
Mm-hmm.
Am I, and it doesn't have to be that you've memorized it all, but even if you're working as if you had an open book exam, get a hypo and look at your outline, which will be basically in your head, and see what you can do with it. Because it's not like you're going to be able to use the material if you haven't practiced it.
It's true. And to struggle now in October or early November is better than struggling, say, after Thanksgiving, which is
right,
usually
it's too late at that point.
Yeah, it's too many few days left until your exam.
Yeah, you don't want to realize like 2 days before a closed book test that you actually have not really been making sense of a material in a usable way for the last 4 months.
Yep. All right, so what about these in-class, fancy, open book exams that you got to take in law school?
Well, I know you sometimes argue, and I think this is probably right, that they're not actually that different from a closed book exam.
And that's just because I like to make everybody suffer like I did in law school.
Right, but it's the same thing. It's like if you have a time-limited test, you have to ask yourself, what is going to distinguish the A answer from a C answer here? And it's not going to be the law. Like, everyone's going to have the law in front of them. It's going to be that analysis. And the questions are typically going to be harder. So, you've got to have a better understanding of the material. I would argue a deeper understanding than someone who just has to do a massive issue spotter with no notes, because it's just like, can you write down the rule? Can you identify the issue? Moving on. A lot of closed book exams are open book exams in class are actually pretty sophisticated because they can be harder.
Mm-hmm. Yeah, because the professor is not going to give you any sympathy for not knowing the rules because you have the rules in front of you. So,
well, they still have to curve it too.
Yeah, they do.
So how are you going to curve it? You have to make it a harder test. more conceptually difficult typically, or you have to make it, longer, more detailed, more issues. Like it has to be more something because you have the benefit of having the law in front of you as a reference.
Yes, but I think where we see people really falter on these open book exams is thinking that they can spend a lot of the time of the 3 or 4 hours
to look stuff
up, which is a horrible idea.
It's like, oh yeah, I'm just going to look up like adverse possession and kind of like refresh my recollection on it. It's like, no, you just spent 5 minutes that you were not preparing to write or writing. That means someone else just got down a page of material on this topic.
Exactly.
Who do you think is going to get the better grade?
For sure. I mean, I did have a few open book exams, and I always had like a 2-page cheat sheet that I would open like a book in a binder. So I had 2 8.5 by 11 sheets of paper with notes, attack plans, maybe rules that I knew I needed to quickly reference. And on none of those exams did I ever dive into my full outline. Because
I mean, I did I had enough open book exams. There were occasions where I was like, oh, shoot, I don't really know. I know that there's an issue about X, but I don't actually really know the rule. Let me try to find it and look it up, which is when you want to make sure that you have a table of contents, you have an index, that you have tabbed your outline. I mean, the most critical thing you can do is bring an index, because then if it's some random thing, like I remember, for example, an issue in property where there was like an issue of adverse possession, but the person who owned the property was a child. And that's one of those things where you're like, I don't think we ever talked about this, but something sounds weird about this. Like, I'm going to double check what this rule is because I think this might be important. And it turns out it's really important.
Right.
Yeah, because you can't toll the statute of limitations until the child is of legal age. So that's kind of the key to the whole question. And I honestly don't think we ever talked about that in class. But it was in whatever property supplement I brought with me, and I looked it up and I wrote it down. So I think, with an open book exam, you have to really think about what are you bringing in with you? What are you making? So something like a flow chart can be extremely useful. For contracts, for example, I had a 3-page flow chart that outlined the entire class. And so I could basically go through that step by step, and I was going to be able to do a pretty competent analysis. You might have a checklist. You might have a list of all the intentional torts, for example, that you need to think about. You mentioned the 2-page cheat sheet. That's another great way to go. The point is you've got to think about what you're going to bring with you that's actually going to be helpful. And again, how do you know what's going to be helpful is that you've tried using it.
So what about something that we get questions about all the time is this idea of students almost pre-writing answers to open book exams. So if you have a torts answer, you basically write the framework for the answer, or as much of the answer as you can, and put that in your binder. So you're just copying word for word a good chunk of your exam answer.
Yeah, I mean, I personally never really found this that helpful, but I know other people who did very well. I'd say try it and see how it works. I mean, it's something like the basic rule for negligence. Again, it's going to be in your head, but if it makes you feel better to have something you can write down. I mean, the problem is if people go overboard and they start trying to sort of impose their framework on the question. And, that's a recipe for disaster because your professor is not asking you, what do you want to talk about here? They're asking you a specific question. So I think it's a balance.
Yeah, I think, many students are looking for the easy fix. This is the answer to my A, and there's just no easy answer.
No, but if you think about something like, say, personal jurisdiction in Civ Pro, that's an area where you've got a bunch of cases, you've got a lot of stuff going on. If you can have a couple of sentence sort of intro ready to go, it's not the worst thing.
No, but pages and pages of pre-written answers, I'm not sure that's going to get you where you need to be.
Yeah, that's completely pointless and a total waste of time.
Yeah.
So, I mean, how are people supposed to stand out on these open book exams if everyone has the law sort of ready to go?
The way you stand out is really by the quality of your legal analysis and your issue spotting and your confidence in the material. I think that, the professors are really going to award you for your mastery. And that means that you need to have practice, really understand the law and really understand the analysis so your answers can be very sophisticated because everybody has the same law. So you have to come up with a way to, make yourself stand out.
Right. And I think it's also, sort of looking like a lawyer, like sounding like a lawyer. In the back of your head, your professor's thinking, would I trust this person in a courtroom? Are they going to represent me well? So, things like the little things like using headers to make your points, using like really quick intro sentences so your essays are easier to read. Tell people what you're going to talk about and then talk about it. So it's not, sometimes you see exams are just like this complete amorphous brain dump, and it's like, what is going on here? So, spending a little bit of time structuring your answer can really pay dividends in the long term.
For sure. And I think that's true for any exam answer. You should plan before you write, no matter what.
Yeah, absolutely.
Absolutely.
Because, grading is like what every professor hates. I have so many friends who are professors, and to a person, they're like, I don't get paid to teach. I get paid to grade.
It's true. It's horrible.
So it's horrible, and they hate it, and it like ruins their life, and it's over the holidays, and it's like, so make it easy for them to follow what you're talking about, and you'll probably do better.
Yeah. For sure. Let's talk a little bit about another type of exam everybody hates, the multiple choice exam. I hate multiple choice. You don't hate it as much as I do.
No, because I'm typically pretty good at standardized tests, but I do not enjoy multiple choice questions in the law because they're really hard.
Yeah, it's true. Does the law really lend itself to multiple choice?
Well, no, because, as we said earlier, the answer to everything in the law is it depends.
Right.
But the problem is when you're faced with a multiple choice question, you have 4 choices and one of them has to be selected. So, you don't really get to explain your reasoning. Occasionally you'll see professors give like wacky exams about like true, false, and explain your thinking.
Mm-hmm.
I don't really understand what the point of that is, but with a typical multiple choice, you've got your little hypo and then you've got your 4 answers and you have to select one of them.
Yeah. I think it's just, all law students want to usually talk and explain themselves because that's why we all went to law school. It's typically because we like to talk and explain ourselves. Multiple choice is just very frustrating for a lot of people. And then, everybody has so much history with multiple choice from the SATs and the LSAT and things like that. If you are not someone who is very good at it naturally, I think it can be a huge, anxiety inducing exam to have come up during final exam times or even midterms. We're hearing about multiple choice quizzes being part of students' midterms this year.
Yeah, and I think one of the reasons that professors like to use these, I think it's twofold. One is it's good practice for the bar exam, whereas you may be aware, you have an entire day of extremely challenging multiple choice questions.
Such a fun day. Best 6 hours of my life.
Yeah, I'm somebody who, got through life on standardized testing, and I came out of the MBE the day of the bar exam literally thinking I had failed.
Yeah.
I didn't even want to go back the next day. I remember talking to like some friend of mine who was taking the New York bar, and they did the essays first and then the multiple choice, but Massachusetts, you did multiple choice and then the essays. And I was like, I don't even think I'm showing up tomorrow. Like, there's no way I'm passing this test. He was just like, you are going to show up. you know?
It's true. Yeah, I had lunch during the MBE day, which in California was the second day after a writing day. I text my now husband, and I think the text was something like, I think I might have just failed the bar.
I think everyone walks out of the MBE.
And so he called, which was the good, supportive, significant other thing to do, and was like, what happened? And I was like, oh, it was bad. It was just really bad.
I remember like certain questions I was just like obsessing over, and my friend was just like, yeah, you might have gotten like those 5 questions wrong. Let it go.
Right.
Maybe if they were really weird, they were probably sample questions anyway. Like, stop worrying about this. But, I think they're really tough. I've taken a lot of standardized tests, and like, this is the hardest one I've taken. So I think it's good that professors are doing this in some way. And typically, even if the questions they're using are not exactly from the bar exam, they're going to be kind of in that realm. Mm-hmm. So this can actually, the MBE questions can be a good place for students to look to kind of get a sense of what are you likely to be asked and how is it sort of likely to be structured? Because I think there are differences from sort of other multiple choice in that in law, like, you're often selecting the least bad answer.
Right.
Which is really weird because it's not just like an objective statement of fact that you have to choose, which fact is correct. Like, what is the date of the War of 1812,
Yeah.
That might be a lot easier. But in law, it's like, you might be able to eliminate a couple of the choices, but those last two, you're like, neither one of these is really quite right. Or they're both sort of right. And so I think getting used to kind of the tricks and the patterns is really critical beforehand, which of course is difficult because your professors typically aren't releasing a lot of these questions.
Yeah, because they're really hard to write. If you've never tried to write a multiple choice question, they're very challenging to write. So professors don't make new sets of them because it would just be way, way, way too much work.
No, I mean, the advantage for them is they're really easy to grade.
Yep.
So that's why a lot of professors, I think, are using at least partially multiple choice. It's like good practice, great, but also way easier to grade a Scantron than to grade an hour essay.
Yeah, especially right around the winter holiday time when they would much rather be doing something else. Actually, one year, one of my students got back her final exam, and on the back of it in pencil was written like a holiday menu for like it was like Christmas dinner or something like that that the professor had written on the back of her exam.
Right, clearly multitasking.
Exactly. I think people get really frustrated because there isn't a lot of practice, but the good news is there is a lot of multiple choice legal practice out there, especially for these 1L classes. So bar questions are such a great place to go for practice. They are very difficult, but if you can struggle with those, what your professor writes is probably going to be not as challenging. And then there are some supplements who actually provide multiple choice questions. I think Crunch Time sometimes does that. Glannon has one of his supplements for civil procedure. He uses multiple choice as kind of a teaching tool. You can get a lot of practice. If you're not sure where to find them, it's a good idea to go to the law library and poke around through the supplements, but also chat with those very helpful law librarians and people who work the library, because they might be able to point you to some very valuable practice.
Yeah, and I think practice, again, is just really the key. I mean, partly to learn the material, because one of the downsides for students of multiple choice is that you can get really specific. So, if you think of a normal essay, maybe there are, 80% of the things you're pretty clear on, and then 20% you're like a little bit hazy. Maybe you didn't finish your outline, or like you weren't there for, you got sick for a week of class, but, mostly you're pretty okay. If you get multiple choice questions on those topics that you're not really clear on, you have a serious problem.
It's very, very true. Yeah. I mean, this is where the professors can really dig into the details.
Yeah, and I think, sometimes they'll use it as a balance. Like I'll give 2 essay questions or 1 essay question in an hour of multiple choice. And that's when you probably can guess, like, well, the multiple choice is probably going to be more on the details.
Yeah. And sometimes, professors know that students struggle with things like multiple choice, and that's where they get their curve. I mean, it's brutal, but that's because oftentimes the essays it's much harder to get the curve on the essays.
Yeah, I mean, multiple choice is easy. It's like, how many did you get right?
Right, exactly.
It pretty much makes your curve for you.
Yeah, so don't ignore it. These are not your SAT and LSAT questions. These are something you need to practice and learn how to approach. And if multiple choice gives you a lot of anxiety, try and think of them as almost short answer questions, and then work with the answer options almost as like whether or not they're a short answer to what the question is asking, than just trying to go through and use I'm going to eliminate the 2 answer choices that don't relate, like we did on the SAT, which doesn't really work on.
No, I think I think what you're saying, I think the better approach for these oftentimes, if they're similar to bar questions, is you actually read the question and then you don't even look at the answer choices until you've formulated in your mind what the answer would be if you were going to write a short answer. Because the problem is if you just sort of look and, some people will say like, oh, you should read the answers first. I mean, that sort of stuff is just utterly confusing, I think.
I think so too.
I think it's a terrible idea.
Yeah,
because all of them are, the answers are designed to sound reasonable.
Right. They're called distractors, and they are distracting because they sound right. And sometimes you read all 4 of them and be like, oh, they all sound right. You're not going to be able to do early elimination like you did on other multiple choice tests.
No. So I think, you want to have a clear idea of what you're looking for before you start looking for the choices, because then you can typically like toss out 2 of them. You're like, no, that's totally not on point.
Yep. All right, what about take-home exams? I did not have any take-home exams other than my legal writing assignment exams in law school.
Well, this might be another Ivy League thing.
Well, I know professors did it in my school. I just don't think I ever signed up for the class. I don't know why.
Yeah, no, I had one my first semester actually, and it was my civil procedure. And the reason that he said he did it is exactly what you said earlier. He's like, when working as a law firm associate, are you ever going to have someone drop a question on your desk and say, I want a full answer 4 hours from now? He's like, that doesn't happen. He's like, but it will often happen that someone will come in and say, hey, there's a question we need you to research. I need this on my desk by the end of the day tomorrow. Right. So basically you have 24 hours to figure this out. He's like, that happens all the time. So he's like, that's what I want to train you for.
Exactly.
And so we had a 24-hour take-home. And I mean, it was brutal. His exams, I mean, this professor used to be a physicist. He was brilliant. But his exams were notorious for being brutally difficult. But if you have 24 hours, how else are you going to curve?
Yeah, that's true. I mean, that's a lot of time.
It's a lot of time. And, like I didn't make an outline for that class necessarily. I ended up TAing it. But the reason I did really well on it is I understood, I understood the professor. So I said, I know that he's going to basically go for something that's really difficult. This is not going to be the easy test. And so I remember people made fun of me because I was really obsessed with this like one aspect of joinder, which was like really complicated. And, it's one of those things you could go round and around on. And like I talked to him and I talked to my friends. They're like, why are you even worrying about this? Like this would never happen in reality. And then that's the exam question he gave us. And I just laughed when I saw it. Because I was like, I don't know what the answer is. And in fact, I don't think there was an answer. Like me and a different TA compared notes like a year later. Realized we'd come out differently on it. Had totally different answers as to like the answer. But, I was glad that I'd gone through that process. Because if you had a really shallow understanding of the class, even in 24 hours, like you weren't even going to see the issue, basically.
Right. I also think professors like take-homes because they don't have to read the sloppy mess that is often the timed exam answer. I mean, they can, require you to do things like proofread.
Yeah, and the expectations are just higher for how this is going to look.
Yeah.
Like you're not going to get away with a stream of consciousness with like tons of typos. It's like you had 24 hours, like use spell check.
Right. Yeah. And they oftentimes will put limits on them because people would just write treatises if they could.
Yeah, of course. So, you're typically... The downside of having more time is you're typically going to have a page limit. So you've got to think more carefully about what's actually really important to include. It can't just be like a stream of consciousness. And also you've got to think about the different time frames. I mean, if you have an 8-hour take home, essentially that's an in-class test. Like you don't have time to be looking things up. You've got to have your outline ready to go. You've got to basically be ready to talk about any aspect of the material. And, you have a little more time to like have lunch and shape your answer, but basically it's in class. 24 hours. You can definitely look stuff up, but you still need to really know the basics of the material. You need to have drilled down, understand it pretty fully. And then you might get something like 48 hours, which basically at that point, to be honest, like it's like writing a paper. You know, if you can't figure out the question and like what law applies in 48 hours, you probably shouldn't be in law school.
Yeah, I think that's true. What about sleep? If it's a 24-hour take home, are you allowed to sleep?
Well, I think you should. I mean, hopefully your school, if they're giving you a 24-hour take-home, has scheduled it so that you don't have other exams afterwards. I mean, if you do, obviously you have to sleep because you're going to destroy your other exams. I mean, in my case, we had, the other exams for the semester were first, and this was our last exam. I mean, even then, I think I probably slept like, 4 or 5 hours.
Right.
Because I think there's validity in sort of getting up and looking at your answers. And typically you'll have a choice about when to pick up your exam, like within a time range. And you want to think about when you work best. So, I know that if I really have to focus on something, I'm a night person. So I do my best work typically between like 10 p.m. and 2 a.m.
Right.
Might be weird, but like I know that. So basically like I got the exam, say late afternoon, read through it, kind of, sketched out some answers, thought about it. I think it was like 2 questions. Wrote one of them, had dinner, and then like the really hard question, I basically wrote until probably 2 a.m. and then I went to sleep, for 4 hours, 5 hours, and got up and looked at it again and then made my final edit. So you have to kind of think about what makes sense for you in terms of staging your time. Because, you don't want to necessarily stay up all night, but also you don't want to leave yourself, like you don't want to run out of time and not finish. You just have to sort of think through and to keep an eye on your time as the time is passing.
Right.
Because it always, you're going to be pressured in the end.
Of course, yeah. All right, well, should students know what their exams are going to look like now? Or let's say, if you're listening to this at any time, like early in the semester, in the middle of the semester, when is it okay for these students to ask about the type of exam they're going to get.
Well, I mean, oftentimes they'll tell you in the syllabus, so that's the first place to look.
Yeah.
I mean, some professors are a little bit like cagey about exams, but I think at any point in the semester, it's completely fair just to ask them, like, is this going to be a multiple choice exam? Is it going to be in class? Is it open book? Is it closed book? Is it a take home? Can you give us like the very basic scenario? I mean, maybe they'll say no, but if it's like a month from your exam and you still don't know if you're having a take home or like multiple choice, that's completely ridiculous. And you should probably go talk to a dean about it.
Yeah, but I mean, I don't know any professor who gets mad about students asking them details about the exam. Don't do it like right before class. Go to office hours if you want to, or email them, but it's fair game. Like, they need to tell you what the exam is going to be like, and they know
right.
that.
Yeah, and a lot of them sometimes are cagey about putting old exams on file. I mean, it's just like this stuff is sort of ridiculous. Like, you basically need to have at least one old exam to work from. I mean, some of them won't do it, but like, they know that they should if they won't. So if they're being like rude about it, it's probably because they feel bad about it.
That's true. But regardless, go talk to your professors. It's really important as early as you can to know what the format of your exam is going to be, what the date of your exam is going to be, so you can start preparing for it, from day one. Like we said, if it's going to be a 3-hour multiple choice exam, you better be taking copious notes on all the nitty-gritty details that your professor brings up in class, because that could totally be, what is
right, and like
tested
tracking,
on the exam.
if you have exceptions, like tracking exceptions, like what's the federal rule, what's the state rule, because those are the kind of things you can be tested on. I mean, the other thing to look at in terms of scheduling is sometimes, you might have a schedule that has you taking 2 exams in a day, for example. I mean, in theory, that probably shouldn't happen your first year, but if something like that is on your schedule, there are rules about moving one of those exams typically, because those are the things you don't want to find out a week before.
Exactly.
Like, you need to deal with that now.
Also, again, I know we've talked about this on other podcasts, but if you're a student who thinks they're going to get any sort of accommodations, or if you're wondering about getting any sort of accommodations, do not wait till the last minute. Please go visit your disability services office at your school as soon as possible, because you do not want the added stress of being unsure about how much time you have or the conditions in which you're going to take that exam leading up to your exams. That is not something to worry about after Thanksgiving.
No, and the other thing, if you do have accommodations, you want to be really clear about what they are. Like, I've heard stories of, an exam that was partly essay and partly multiple choice, and the student didn't really understand they were getting extra time. They thought they had, twice as much time as they actually had for the essays, because they didn't really understand that they were going to get like half the extra time on the multiple choice. Stuff like that is just a freaking disaster that does not need to happen. So you just want to be really clear in advance on what exactly you're getting.
Yeah. So you don't want surprises during final exam time.
No, and another possible surprise place, which I've had happen before, is with an open book test. You want to be clear on, can you bring anything you want to bring? Mm-hmm. Are there limits on what you can bring? Because you don't want to find out a week before that, oh, no, I was actually sort of thinking, the professor says, that, you can only bring materials you personally have created. And then you have people who've been working with someone else's old outline for the entire semester and adding to it. And it's like, well, did they create that or not? You want to understand from the beginning what you're going to be allowed to bring.
Yeah, for sure. All right. Well, I think that's all the time we have for today to talk about different types of exams. If you have enjoyed this episode of the Law School Toolbox podcast, please take a second to leave a review and ratings on iTunes. We would really appreciate it. And be sure to subscribe so you don't miss anything. If you have any questions or comments, please don't hesitate to reach out to myself or Allison at lee@lawschooltoolbox.com or allison@lawschooltoolbox.com, or you can always contact us via our website contact form at lawschooltoolbox.com. Thanks for listening, and we'll talk soon. Good luck on your upcoming exams, whatever type you may have.